Hello and welcome everyone. Today we are going to take a look at a very interesting decision, and it's particularly interesting because it is the first of its kind. It's the first decision of the Unified Patent Court regarding a front-related dispute. We had some months ago a first decision about an SEP, but there the court did not really deal with front issues, and this is the first time where the UPC did that actually. So it's very interesting to see some of the thoughts of the UPC on front and how it intends to deal with these cases, and get a first impression of how the court is positioning itself, maybe also looking at how the court positions itself compared to other national courts in Europe, especially the German courts. We have ever since gotten a second decision of the UPC on a front-related case that was delivered in the end of December. We're going to take a look at that in one of our next webinars, of course, as well. Now here in this case, the case was between Panasonic on the claimant side and Oppo was the defendant. The court that decided this case was the Mannheim local division of the Unified Patent Court. And the story behind that was, let's say, a very common story when we have a front litigation. So there was an approach by Panasonic towards Oppo already back in July 2019. Then there were meetings following that first contact. There were patent lists shared, there were claim charts shared with Oppo, but there was no agreement at the end of the day. So that Panasonic started litigation against Oppo in July 2023. And this was not only in before the UPC, but it was also in other jurisdictions, including the UK, where the case, interestingly, was joined to a certain extent with a case that Panasonic had filed against Xiaomi. So here, the proceedings, all of these proceedings run in parallel, and the courts, as we're going to see, only the UPC delivered a decision here. What was interesting in these proceedings was not something that happened directly in these proceedings, but something that happened in parallel. And this was a development in April 2024, where the European Commission decided to intervene in another dispute which was pending before the appeal court in Munich in a case between HMD and VoiceAge. The Commission filed an amicus curiae brief where it took some positions, or it made some suggestions, let's say, to the court of how to apply the Huawei ZTE framework, which is a framework setting up specific obligations for patent owners and implementers when it comes to front negotiations. There, the Commission expressed certain views and asked the Munich court to consider that, or even make a referral to the Court of Justice of the EU seeking guidance of how to understand these obligations and how to interpret this framework. Now, again, this was not directly filed in these proceedings here before the UPC, but it was an important part of the decision because it was discussed a lot also in this context, in the context of these proceedings. And we're going to see in a moment that the UPC also responded to a certain extent to the comments of the Commission and took positions sometimes following what the Commission said, but mostly rejecting the views of the Commission. So this is one interesting thing to keep in mind here regarding these proceedings. The further interesting thing is, let's say, the end of these proceedings, because in October 2024, that was shortly before the judgment was delivered here, the parties apparently reached an agreement on license terms in principle. And that led to, in the UK trial, in the parallel trial in the UK, the parties to ask the court to stay the proceedings in order to be able to finalize the settlement. Notwithstanding this, the Mannheim court, the Mannheim local division of the UPC, delivered its decision. And this was the judgment from the 22nd of November. And what was interesting here is that the court found very much in favor of Panasonic. So it found infringement. It dismissed the invalidation action which Oppo had filed here, and the UPC now is also in a position to decide upon invalidation as well. But also granted preliminary damages amounting to 250,000 euros to Panasonic. And what was also very important, of course, granted an injunction to Panasonic, which would extend to to five member states of the EU, Germany, France, Italy, the Netherlands, and Sweden. Apart from that, what the court also did was to reject a claim that Oppo had raised here to make a determination of front terms. There was a very complex construct here of requests and ancillary requests that Oppo had raised here, so we cannot really go into the details of that. But what is interesting, and we're going to take a look at that at the end of the presentation, is the feedback that the court gave regarding the question whether the UPC is going to be prepared to, let's say, make front determinations, or particularly whether it has the jurisdiction to do front determinations. So these are all the parts, all things that we're going to discuss today. As far as we can understand, the settlement has been signed in the meantime between the parties. The license agreement has been signed, so it is, at least as far as I understand it, for the moment, rather unlikely that we will have appeal in these proceedings here. Now, when we look at the reasoning of the court, the main part of the legal reasoning was dedicated to the question whether an injunction should be granted here or not. And here, the court basically decided to grant an injunction because it found that there were no grounds for not exercising the discretion it has to grant a permanent injunction. This is Article 63 of the UPC agreement. Maybe here just a very short comment. If we compare this to the German case law so far, we see here a slight difference because here the court speaks about the discretion to grant a permanent injunction. Under German law, we have not really a question of discretion here. The injunctive relief is a substantive right, which means that the court must grant injunctions if it's requested and the conditions are met. So here, maybe a slightly different approach because it is in the discretion of the court to grant a permanent injunction or not. In the present case, the court did that. And it did that because it saw, on the one hand, that the SEPs are basically patents like every other patent, and the exclusionary rights of arising out of SEPs are not curtailed in any sense, of course, provided that the conditions of the Huawei ZTE judgment are fulfilled. So we're going to take a look at that in a moment. Then the court also saw no obstacle in proportionality considerations here that would basically require the court to limit the injunction or to withhold an injunction. And finally, the court also saw no problem with the parallel UK litigation in granting an injunction here. Here, particularly because, in contrast to the Panasonic case against Xiaomi in the UK, which ran in parallel with the Panasonic Oppo case in the UK, the Court of Appeal did not determine a preliminary license in favor of Oppo. So the court saw really no reason here not to move on with its decision and not to grant the injunction as requested by Panasonic. Here, I think to start with some interesting remarks or views of the court on whether SEPs should be able to receive injunctions and or whether you should grant injunction based on SEPs. And here already we see a very clear positioning of the court that this should be the case in principle. The court disagreed here with the view of the UK Court of Appeals and the other courts in the UK, if we would see the case law in the last couple of years, which seem to, let's say, give SEPs focus more on the monetary aspects of SEPs and putting the front determination as a priority more than questions of infringement or than questions of granting an injunction to stop infringement. And the UPC here does not agree with that. It made clear that in the view of the court, SEPs are not patents assigned solely a monetary substance, meaning they're not just patents that basically give you a claim to get licensing income. They are patents that have exclusionary rights, and here the court referred to the Court of Justice of the EU, which in the Huawei ZTE case, which we mentioned before, it made clear that SEP owners can exercise these exclusionary rights from the patent, provided, of course, that the steps laid down in this decision are taken. And here the court also said that patent enforcement is not per se abusive in antitrust terms. Even if you have a market dominant undertaking, you have, again, to look at whether the steps have been taken that the Court of Justice of the EU has determined. And if yes, then injunction should be granted. The court referred again to the CGEU, saying that the court acknowledged that there is a need to protect IP rights and secure access to the courts. So having said that, again, it criticized this view taken in the UK, where monetization is put as a priority when it comes to SEPs, and said that this line which the UK courts are taking is not in line with the EU law. And what is more, the court also saw here, let's say, more fundamental issues, because it said that treating SEPs as patents that are deprived of their exclusionary rights violates not only the EU Charter of Fundamental Rights, the provisions that talk about protection of property, but also minimum constitutional guarantees in Germany, again, concerning the protection of property. So here I think a very strong statement of the court that injunctions for SEPs will be available if these conditions under Huawei ZTE are met. Then the court turned to proportionality, and here basically rejected the notion that proportionality considerations should stay in the way of granting an injunction here. This discussion is something that we have seen a lot, especially in Germany, where the main argument is to say that although there is infringement of a patent, this patent has a value which is not significant enough, and especially is in no relation to the harm that you could have by enforcing an injunction and putting someone out of the market, for example. Now, these arguments were made here as well in these proceedings, but the court was not convinced that this could play a role here. And what the court said, that in principle, if you have a front defense, then these proportionality aspects are comprehensively considered already when you address the arguments concerning the proportionality defense. So here, what the UPC seems to think is that if in the front context, if you have, let's say, substance enough to argue a front defense based on, as we're going to see in a moment, predominantly competition law considerations, then on top of that, proportionality will rather not be an issue. And having said that, it looked also a bit at the specific arguments that were made here. One argument was that proportionality would require the court denying an injunction here because Panasonic does not manufacture competing products to Oppo. So it does not really need an injunction to protect its own products here. It only needs money, and therefore it should not get an injunction. But the court said simply pointing out on to that fact does not really suffice to have the court thinking about this proportionality defense. And apart from that, Oppo did not show anything else that could be relevant in this context. On the contrary, maybe an interesting comment of the court here is that Oppo's argument that most of its sales are in China and that's the main place of its business, rather indicated in the eyes of the court that granting an injunction that would cover the EU or let's say the member states that are part of the UPC is not really convincing because the harm that would be caused to Oppo's overall business would be relatively insignificant, considering that the main business is in China and not in the EU. So this was the court's views on proportionality. And then the court turned to the front defense. And as we said already, the front defense was dismissed, the front defense that Oppo had raised here. Some interesting basics here. The legal basis for the front defense was a competition law, EU competition law. This was something which is very similar to the German case law so far, where competition law, especially Article 102 of the TFEU, which is the provision which prohibits an abuse of a market dominant position, is the source of this defense. Contractual elements here, basically the front commitment towards the STO did not really play much of a role here in the present proceedings. The court focused, and probably also Oppo pleaded the defense based on competition law. Now here the court made clear that it applies EU law and that it is also bound to the decision of the CGEU and the guidance that the CGEU provides. There was some debate before this judgment here about whether this is the case or how far the UPC should be bound to EU law. I think here it's pretty clear that the court assumes that EU law is binding law and it's also binding for the UPC. The interesting question that was raised in this context here was, however, whether they should stop the proceedings basically and make a referral to the CGEU, asking the CGEU to clarify the content of the obligations of the parties under this competition law inspired front defense. This is again something that came from the amicus brief of the European Commission in the other proceedings we discussed before. And these arguments were brought here as well, suggesting that, as the Commission had suggested in this amicus brief, the UPC should also stay its proceedings here and ask guidance by the CGEU. Now, the court rejected that here. The UPC did not decide to stay the proceedings and make the referral. It said, of course, the Commission's views are something you should consider, and as we're going to see in a moment, the court indeed positioned itself towards the views that the Commission expressed in the amicus brief. But the court also clarified that these views are not binding to the court and are not binding to the UPC. So basically here, a referral would only make sense if you would have questions posed that would not concern only this case here, but would have broader implications. And the court, the UPC, did not see that this was the case here. It found that only the questions that concern the specific case are raised in these proceedings and that they can be solved by the balanced principles that the CGEU has set up. Then it's not only that, of course, the court also mentioned that there is already guidance, not only by the CGEU, but also by national courts in Europe, highlighting the courts in the Netherlands and in Germany here, which have already provided insights of how to deal with this framework and how to understand these obligations. And we're going to see also that a lot of the findings, especially of the German case law, were used here in this decision as well. Then, interestingly, also to see how the court seems to approach the Huawei ZTE framework. And this is also, let's say, linked also to the UK case law and the different approach that they have been taking there, as we said already, prioritizing the front determination as the main element of front cases. Here, the court said, if you look at the Huawei ZTE judgment, the CGU does not focus on the determination of license conditions disregarding the parties' conduct in negotiations. So this is here the very big question, because especially I think in the Optis Apple case in the UK, the court said how parties behaved in the negotiations is not really relevant. You need to have extreme circumstances in order to dig into that. The main thing that you should do is to set the rates. But here the court said this is not how the CGU sees things, because the Huawei's key objective is to establish a negotiation program with mutual duties, which then would allow the court to make a competition law assessment if parties do not agree and end up in litigation. And front determination is only one single element of this program. It's not basically the main focus, or shouldn't be the main focus. On the contrary, the court seemed to believe here that focusing only on the purely economic rate determination without considering the parties' conduct at all would violate mandatory EU law. So would not be in line with this case law and violate mandatory EU law, which the UPC needs to observe. So here again, a clear statement of the court, I think that pure rate setting is rather unlikely to happen before the UPC. So how the parties behaved in negotiations will always play a role. We're going to see some nuances on that in a moment, but I think what we can see from that here is that front determination is not going to be maybe the main focus points of UPC proceedings. The parties will have to deal also with how they negotiated and how they acted and how the conduct was during the negotiations. This is not an element that the court is going to set aside, I think, here. All right, so having said that, the court went then into the individual obligations under the Huawei ZTE framework. And there, as we will see, it addressed also the views that the Commission had expressed in the amicus brief, and also laid down, let's say, the standards that it's going to apply here also in the future. If we look at this, let's say, holistically, we will see that there has been, of course, this contrast between the views of the Commission on the one hand and especially the German case law on the other hand. The court in some cases took, let's say, the middle way, giving right to the Commission to certain aspects, but also confirming the case law of the German courts in other aspects. It is a mix, but predominantly the court seemed to create its own approach here and its own view. Regarding the notification of infringement, this is the very first step of the Huawei ZTE framework. So the patent owner, before filing an action, is required to get in touch with the implementer and notify him that there is infringement and there is a need to take a license. So here the court made clear that this can be done by providing claim charts. So if you provide claim charts to the implementer, you regularly, or in any case, this is sufficient to make a notification of infringement. There was some debate here about what else should a notification of infringement include. Particularly, the Commission had taken the view here that the notification letter itself should include all relevant information. and not, for example, have references to other sources or a website, etc. All relevant information should be included in the notification of infringement. According to the Commission, if this is not the case, then the notification has not been sufficient. The court, the UPC, disagreed here. It found that this is a very formalistic understanding that cannot be followed, because one reason is, of course, that the CGU laid down no formal requirements. So taking this formalistic approach is not supported by the CGU either. And in the eyes of the court, requesting this formalistic format for the notification of infringement has downsides, because it's likely to lead to confusion rather than transparency if you just add as much information which might be also irrelevant in the letter. This would not serve the purpose of letting the implementer know that there is a need to negotiate and to take a license. So here the court really disagreed with the Commission and adopted a far more flexible approach of what information the notification letter should include, and especially in which format the notification should be made. Then, having said that, it found that Panasonic had made a sufficient notification of infringement here. As we said, Panasonic had provided patent lists, had identified the infringing products in presentations and letters, etc., and had also shared claim charts for several patents. There was a discussion here about one specific claim chart. Panasonic had provided a claim chart for the Chinese member of the patent family of the patent in suit, which included also an express reference to the patent in suit. But again, the claim chart was not for the specific European patent here that was asserted in the proceedings, but it was a claim chart for the Chinese member of the patent, or of the same patent family. Oppo tried to draw some arguments from that and say that, well, this meant that the notification was not sufficient because the Chinese patent had a broader scope than the patent in suit here, so that in order to identify that, you would have required more input on the side of Panasonic, so that the notification was incomplete in a sense here, or not sufficient enough. Here, the court was not convinced by that. On the contrary, it criticized this type of argument by saying that this is an example of how an implementer seriously interested in a front license should not behave. Because if this was indeed an issue in the eyes of the UPC, Oppo should have asked for clarification much earlier and not only raising this point in trial, but also raising this type of formalistic arguments or objections here that does not correspond to the spirit of the CGU Huawei judgment, which very much focuses on business practice and how things are done in practice. And this is rather a very secondary issue here that you didn't expect that it would have such an importance. So here the court finally said notification of infringement that was sufficient. There was no issue here. Then the court moved to the second step of the Huawei judgment, and this is the issue of willingness. And again, the CGU requires the patent implementer that receives the notification to express willingness to obtain a license. And this then triggers a duty for the SEP owner to make an offer and counter offer, then, etc. Now, this was a part which was very much discussed here, because there was the controversy also from the amicus brief of the Commission that played a role here. Here, the Commission had basically taken a position that this requirement to express willingness should basically be limited to saying that you're to responding and saying that you're willing to take a license, and not much more beyond that. So basically responding to the patent owner and saying that you are willing to negotiate should more or less suffice and trigger the obligation to make an offer. There was This view is in contrast a bit with the German case law, which has been looking more holistically to the behavior of the implementer when it comes to assess whether there was willingness or not, by looking, for example, on the overall behavior, including a counteroffer that's being made and the conduct in the subsequent negotiations, by basically looking whether they had been target-oriented, as the courts have defined it, engagement in negotiations on the side of the implementer. And now here, the UPC again chose a middle ground. On the one hand, it said, of course, when we're talking about this declaration of willingness, this initial declaration is the starting point of negotiation. So you don't need to have much more to keep to kick off the negotiations. So if there is declaration of willingness, this should of course suffice. But on the other hand, and here it was much closer, the UPC was much closer to the German case law. It said that this declaration shall not be mere lip service, but seriously meant. So the wording alone is not sufficient. You have to look at the overall behavior again. So you have to have an overall view of the behavior in order to be able to make this assessment. And again, this is something closer to the views of the German case law so far. What the court said here very clearly is that the behavior remains relevant, the behavior of both parties, because both parties must negotiate in good faith towards an agreement respecting business practice. So what you will need to ask yourself basically is whether the behavior sufficiently serves the claim of the negotiation program under Huawei ZTE, which is to allow for target-oriented negotiations that lead to a timely conclusion of a front license. Again, behavior is not something that is irrelevant when it comes to the assessment of willingness, but you have to look here at both sides. And the court also said here the behavior and the requirements of the behavior can change in the different negotiation stages based on the individual case. What usually is going to be required is for the implementer to react to the SEP owner's offer, except from extreme circumstances. For example, when the offer is definitely not proper to start negotiations upon. And the UPC also made clear here that it is expected that this reaction and any objections should be raised before trial. Doing that only in trial is not sufficient. The court made, however, one clarification here, which departs a bit from German case law and follows more the views of the Commission. And that is that the analysis of the willingness should not focus only on the behavior of the implementer. And the example that the court used here was particularly the way the court would look into the counteroffer that the implementer had made. Because as we've said already, German courts tend to take the entire behavior of the implementer into account when it comes to assessing willingness, meaning not only the direct reaction to receiving the notification of infringement, but also what they've done before, including also the counter offer that they had made to the patent owner. And if this counter offer is, for example, not front, then this speaks for an unwilling implementer. But the court said here it is incorrect to assess willingness or unwillingness based on the implementer's offer or counter offer only, without examining the SEP owner's offer before. So the court said here you have to look at the SEP owner's offer again. If you draw arguments for the implementer being unwilling because of the counter offer it made, you cannot do that without looking at the offer of the patent owner that had been done before. Because the court saw here a high risk that if you do that, the SEP owner's offer will not be examined at all or only superficially in the proceedings. And in the eyes of the court, and In this regard, it agreed with the European Commission this would not satisfy the case law of the CGU and in Huawei ZTE. So basically, you need to examine always the SEP owner's offer, provided, of course, that initially there was not a sufficient declaration of willingness. So if there was no reaction at all, for example, then you don't need to go into the SEP owner's offer. But if the implementer has done enough to, let's say, kick off negotiations, then you should look at the SEP owner's offer definitely. Because the court found that it is insufficient to focus on willingness without assessing the offer of the SEP owner at all. And of course, after you have confirmed willingness, it's not sufficient just to focus on offer and counter offer without ignoring parties' behavior. And this was made even clearer by the court by saying that if you reach then the stage where you need to look at offer and counter offer, you cannot do that by checking in an isolated manner whether the numbers fit or what are the rates and how the rates are calculated. But in this assessment there, you need also to include the specific negotiations and the parties' concrete behavior. And the court gave two examples here. For example, on the one hand, the implementer cannot make a helpful offer if it's not aware of third-party license conditions. And on the other hand, the SEP owner cannot make a helpful offer if the implementer willingly keeps secret, for example, the extent of use of the technology or economic framework conditions, for example, market selling prices. And this is something which the court very much highlighted, as we're going to see in a moment. So here, maybe to keep in mind that the court sees an importance still in looking at the behavior of the parties, looking at the concrete negotiations, how the parties led the negotiations. And this is something that the court still will consider also with respect to assessing offers and counter offers in this context. So having said that, the court then went to Oppo's behavior here and found that in principle this initial indication of willingness was given here. So this initial declaration was sufficient. The things that Oppo had done before the trial had made sufficiently clear in the eyes of the court that it was interested into a license. The fact that it didn't use a specific wording, for example, what the wording are derived from the UK High Court decision that it's willing to take a license on whatever terms are in fact front, did not play a role here in the eyes of the court because it said even if you do that, you can still be unwilling. So it was not very important. What was important is the fact that Panasonic did not contest any of these declarations that Oppo had made, but instead launched negotiations. And in the eyes of the court, this was also, in a sense, proof that these initial declarations of Oppo were sufficient because otherwise Panasonic would not have started negotiations, would not have provided material, etc. However, although this initial willingness was there, the court very clearly found, as we're going to see in a moment, that Oppo did not act constructively and criticized many aspects of Oppo's behavior. But before doing that, the court, as it's mentioned already, looked at the offers of Panasonic. And here it applied a standard which is partly very similar to the German case law so far. So it's made clear that the SEP owner has to make an offer and also must elaborate why its offer is front. And for that, it's not sufficient just to indicate the mere mathematical factors here, meaning just providing the numbers. You have to go a bit deeper than that. However, the court made also clear that there is some flexibility here. The extent of the explanation depends on the status of the negotiations. This means also that there is no need to always directly disclose names and conditions of third-party licensees. So this depends also a bit on how the other side, the implementer, has acted. But in any case, this is something that is expected from the SEP owner to explain why the offer is front. What is not required, on the contrary, is that the patent owner makes a fully formulated written offer. This was an issue discussed in these proceedings here. Oppo was of the opinion that this obligation to make an offer means that the patent owner must present a document which is basically ready to be signed, and anything else less than that, so for example, just term sheets, etc., would not suffice. So that this means vice versa, that the implementer, Oppo in the present case here, would not be obliged to engage in negotiations on this basis. Now the court rejected that, and it said Huawei ZTE does not require to present a fully formulated written offer that's ready to be signed. And here it looked at the business practice again and noted that it's very uncommon in business practice to start negotiations with drafts, contractual drafts that are ready to be signed, especially when there is no consensus even on key economic aspects. On the contrary, what you can do, and is sufficient, is to show the key economic framework conditions, which would allow the implementer to assess the offer and to assess whether it needs to make a counter offer. So again, here, this, let's say, more formalistic argument was not accepted by the court. What the court then also clarified in terms of content of the offer is that front is a range. So there is not one single offer that is front. There are possibilities within the range that the patent owner can use. And what the court also clarified here is that there is a leeway that the patent owner can use, meaning that it is not obliged to offer to make an offer on the lowest price within the front range, or it's also not obliged to apply the calculation method preferred by the implementer. So within this front range, the patent owner can select where to stand. Basically, it's not definitely obliged to take the lowest end of the front range and make the offer on that basis. And having said that, the court also said if in this context, reasonable means that you should not have an unjustifiable deviation from comparable circumstances, whether it's about other third-party agreements or court decisions which refer to similar facts. So this is what reasonable means, and you look at comparable circumstances, and based on that you can make your assessment. Having said that, the court found that the last offer of Panasonic particularly was front. The court saw no issues with Panasonic's explanations why its offer was considered to be front. It said there was a lot of information provided, and important information, sufficient information. There was a presentation in a video call. Panasonic also had provided with a top-down analysis. And looking at the behavior of Oppo, the court also said Panasonic had not been obliged to disclose comparable licenses from the start. And when it did, then during trial, the court confirmed that Panasonic's terms that were offered to other licensees were matching basically the statements that Panasonic had made in the proceedings. So all of that made clear in the eyes of the court that at least the last offer of Panasonic was front. Then there was an argument here that Panasonic had changes in its offers if you compare what they had offered in the beginning of the negotiations and then what was offered later on. And from these deviations, the argument was drawn that at least the first offers were not front because Panasonic deviated from that and made, let's say, lower offers or different offers. But the court said here you cannot really extract this conclusion per se. Adaptations of the offers are possible when you get new information. And in the present case here, the court found that Panasonic had been able to justify the amendment that it did, or the changes that it did during the negotiations regarding its offers by objective means. So the court saw here also no indication that you could consider the last offer especially not to be front. On the contrary, the court was not very much impressed by the behavior of Oppo here, and it raised several concerns of how Oppo had behaved in in the negotiations, and this was more or less the reason why the court found also in favor of Panasonic here, because it was very critical towards Oppo's behavior in the negotiations. It started with the fact that Oppo had rather not been very active in the negotiation. It raised no questions or concerns or made no counter proposals, and did that only in trial. The court again found that this was belated, and was also not very much keen to the argument of Oppo that they should have not done anything before, basically because there was no formal offer on the side of Panasonic. The court again found that raising this was not good faith behavior, because again you would very much focus on formalistic aspects. What was even more criticized by the court, however, was the fact that Oppo had refused to provide sufficient information about the extent of use of Panasonic's patents in the present case. And basically, what Oppo had refused to do is to disclose actual use, to disclose actual sales figures. And instead, they relied on third-party data, even for their own sales by IDC. And the court said, well, this is not correct. If you have, especially if you are looking to receive a lump sum license, then you need to share actual sales figures. And if you don't do that, it is a problem. It is a problem also if you make a counter offer, which is not based on actual sales figures, as Oppo, had done here. That's why the offer was considered, counter offer was considered not front by the court. So the court said, if you want to do that, you should have disclosed actual sales figures. Since you didn't do that, the counter offer cannot be front. The court then also mentioned that Oppo provided no information on actual sales figures even after the counter offer was rejected, and this was problematic. Looking at the further obligations that Oppo has, which are to provide security and give information about the use in the past, in order to be able also to calculate the security amount that needs to be provided. And here the court said again, actual sales numbers are necessary in order to be able to look and to confirm that the amount of security that the implementer has to pay is sufficient. You cannot do this based on third-party data and IDC data. The fact that Panasonic did not provide also actual sales information of its other licensees was not considered to be harmful here, because the court saw that there are confidentiality interests in this regard, but mainly because the court said if you as an implementer do not provide this information, you cannot expect the patent owner to do so. So you should be treated as you treat the others, more or less here. Then two last elements. The court also found that a security payment that was as a security provided by Oppo here was not sufficient either. Not only here because there were no insights on the actual sales numbers so that you could see whether the amount was sufficient or not, but here the actual guarantee that Oppo had provided did not rule out that you could have a total loss in case of insolvency. So the court found that this was not satisfactory. This was not enough for security. And apart from that, the court also criticized Oppo's behavior in the proceedings, especially some positions that Oppo had taken during the trial. And here the court found that they had taken self-contradictory positions. For example, by saying that the court is not competent, initially contesting the jurisdiction of the UPC in general, but then asking the UPC to make a front determination. So the court said here, this does not match, basically. If you say, I'm not competent to decide the case, but then ask me to make a front determination, this is self-contradictory. Then the court also looked at the pleadings and identified that Oppo had argued that only global rate setting is front. But on the other hand, initially it asked for a front determination only limited to UPC territory, US and Japan, and keeping the option open that the main part of the license is going to be set by the Chinese courts. So this was something the court also considered to be self-contradictory here. This finally, this element that Chinese courts should determine the main part of the license was heavily criticized by the court as well, saying that this is something that showed that Oppo did not act in good faith. And why is that? Because the court said a willing implementer would not add further complexities by seeking rate setting in different courts, especially if there is no international treaties giving the priority between the national courts of who has to decide first. And the reason for that is that you can very much expect conflicting decisions then from the different courts, which then would most likely lead to appeal proceedings, and all of this delays the signing of a license. So an implementer who is willing would not really go down this path, because at the end of the day it is used only to delay things and not really to have a sufficient front determination. So this was the part regarding the front defense and the obligations, which was again the major part of the decision. And I have only one final element to discuss, which is the question about the issue which spoken in the last slide, which is the front determination. Here there has been a lot of debate about whether the UPC is going to go down this path and make front determinations as the courts in the UK do, or the Chinese courts do as well, or whether it would choose more the German approach, where you didn't have, let's say, the court actively setting terms so far. A lot of debate about that. As we've said already, Oppo asked the court to make a front determination here. The court did not do that because it especially found that it could not do this front determination based on the counteroffer of Oppo, which was the first request of Oppo, because as we said, it found that this counteroffer had not been front. But what the court did was to confirm that the UPC has jurisdiction for setting terms of a front license. So it did not do the actual exercise here, but it confirmed that in principle, the UPC has the jurisdiction to do that, will be able to do that. The court relied mainly on one provision here. It's Article 32, 1A of the UPCA agreement. I have the wording here. So here, this provision says that the UPC shall have exclusive competence for infringement actions, including counterclaims concerning licenses. And the court understands that this is basically disputes which are over existing licenses, but also disputes that refer to the conclusion of a new license agreement. And whether the claim basically for concluding a new license agreement comes from competition law or it comes from the Etsi-Frant Declaration is, in the eyes of the court, irrelevant regarding the question of jurisdiction. So here, the court, I think, made clear that jurisdiction is there, and eventually, if the case is pleaded maybe differently, or the circumstances of the case warrant a different approach, the court, in principle, would do a front determination. But again, in the present case, the court did not do that. It rejected these requests of Oppo.